Hello?
Hello, can you hear me?
Yes, can you hear me?
Yes, I can. I've been waiting to be let in for 5 minutes.
I've been waiting to let in too, and I rang Quello. He's been doing some exam, which is the reason why
All right, okay.
he hasn't let us in. How are you?
Fine, thank you. Did you get my...
I have just got it, yes.
I don't want to... Quello, are you about to let in other people?
Good morning.
Good morning.
Hello?
The breakout room should be open for you to go into.
Okay, let's do that.
Good morning, everyone.
Morning, Mr. Quaylen.
Morning.
All right.
I don't think that individual has rights of audience. All right. I'm just waiting for counsel in Jeremiah Dill to join us. I will leave you all, however, in return.
Thank you.
How's everybody doing?
Fine, Mr. Horstman, how are you?
Not too bad. Nice to see you all. It's been a while.
Yeah.
Who is the lucky counsel that is late? No, don't answer.
I think Mr. Pettingill appears for one of the appellants whose judgment is due this morning, but apparently he's stuck in the waiting room.
He
Yeah.
appears for Jeremiah Dill.
And without Quayler being here to tell that too, I'm not quite sure what to do.
Maybe email him.
I'll WhatsApp him.
Yeah.
Mark is waiting to get in. Mr. Pettingill is waiting to get in, Alan.
Yeah.
Good morning.
Morning.
Good morning, Chief Bermuda.
Yes, I was waiting for you to let me in. That's what I was waiting for.
I'm getting used to being synced on Nicholas.
No problem.
All right, I'm going to start with Kiari Tucker. There's no sense in holding counsel. I'm waiting for Mr. Pettingill and Ms. Greening to appear for Mr. Dill, so we'll go ahead and get started.
Mr. Quayler, Mr. Pettingill has indicated that he's in the waiting room.
He's not in my waiting room.
Well, could he have clicked the wrong link, maybe?
Perhaps you have a means of communicating with him?
Indirectly, I suspect, but I can try.
If
I
you
can
don't
try and
mind.
email him.
I mean, I've only sent him one link, so I can't see how you'd have any confusion getting in.
Right.
But go, if you can, Mr. Richards, I'd be grateful for you to try to get him on while I go ahead and let the parties in.
I'll give it a whirl. Thank you.
Okay, thank you.
Morning. Morning. Hello?
Yeah, we can hear you.
Okay.
That's not Mr. Tucker.
It's Mr. Dill.
Good morning, Mr. Dill.
Morning. What do you want to talk about first? Then they gave me the line up. They say you go first and then talk and then.
All right, good morning, everyone. This is the Court of Appeal for Bermuda calling criminal number 13 of 2018, matter of Jeremiah Dill against the Queen for a handing down of the judgment.
For the reasons contained in the judgment that we now hand down, the appeal is dismissed.
Grateful, my lord.
Thank you. May I have Mr. Kiari Tucker? Six of 2019.
Good morning.
Morning, Mr. Tucker. Calling criminal appeal number 6 of 2019, Kiari Tucker against the Queen for a matter of handing down of judgment.
For the reasons contained in the judgment, which we now hand down, the appeal against conviction is allowed. The convictions are set aside and we remit the matter to the Supreme Court and order a new trial.
Thank you, my lord.
Are there any consequential matters that need to be dealt with?
Not at this time, thank you.
No.
There is I'm sorry, there is the sentence appeal, but that's now moot, so it can simply be
Moot.
abandoned.
Yes. Thank you both very much.
Thank you.
Thank you, my lord.
Thank
My
you.
Lord President, Mr. Pettingill has now joined the proceedings. He appeared as counsel on behalf of Jeremiah Dill.
Right.
If you wish to restate what the court's order was.
Mr. Pettingill, we've just handed down the judgment in Dill in which the appeal has been dismissed.
Thank you, my lord. First of all, I apologize. I was here. I could see you all. I don't know what went wrong with trying to get on, but I was here at the time.
Don't worry, it's something.
So the appeal's been dismissed, my lord. I'm obliged.
Right, thank you.
Thank you. I gather we'll get the judgment at some point.
Thank you. You can come.
We'll
Yes,
get the judgment.
Mr. Dill.
Huh?
I'll call you right now.
Okay, thanks.
Thank you, my lord.
Thank you.
All the best.
Right.
Okay, thank you, everyone. So the only parties now remaining will be those responsible for Wheatley.
Yes. And have we got everybody in Wheatley? No, we haven't.
Mr. Wheatley is on his way. He's in a
Thank you,
separate
sir.
area from these gentlemen here. Yes.
My lords, whilst we're waiting for the respondent, I'm being advised by a colleague that I may be buzzing. Are your lordships and your ladyship able to hear me clearly?
I can hear you.
Yes.
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 Thank you.
Whilst we're waiting, I should give notice that last week I had some problems with my computer, which I gather I am not alone to have a particular type of computer on a Zoom hearing, in that it would self-mute, as a result of which people couldn't hear me. I hope, with the assistance of my chamber's IT personnel, that has now been mended, because they have reloaded a new version. If chance it hasn't, so that you can't hear me, it's necessary, I'm afraid, to make some visual sign so that I unmute that which has, on this hypothesis, self-muted.
Just smell it.
And of course, if your lordship is asking me a question and it is apparent that I am not hearing your lordship,
Yes.
lordship could give a hand signal so that I...
Yes, we will do that. I'm sorry that we have been delayed for a number of reasons. Our arrangements usually are that we sit for 3 hours and then have a 3/4 of an hour break. Subject to this, we have found that Zoom hearing for 3 hours is quite tiring, and therefore we will take a break in any event after approximately 2 hours. So, Mr. Richards, I think it's for you to kick off.
Lord, yes. So, as your lordship knows, this is an appeal brought by the Crown against a sentence imposed by learned acting Justice Juan Wolf in respect of the defendant's plea to a single count of conspiring to defeat justice contrary to section 128 of the Criminal Code.
Is it actually conspiring to defeat, prevent, or pervert?
Yes, well, my lord, I'm not quite sure how significant ultimately that may be with respect. The heading of the section
Yes.
his defeat, if I recall correctly.
Right.
I specifically pleaded the form of the offence that involves preventing the course of justice,
Yes.
because to make it clear that in this case, the defendant's actions had the consequence of preventing proceedings that ought to have been conducted before the magistrate's court from taking place as a result of the suppression or destruction of the relevant traffic tickets. So the course of justice that ought naturally to have followed in each of those cases didn't, because of his actions. And so that's why the particulars are pleaded in the way that they are. But your lordship, of course, is right. It can be done in a number of ways.
Yes.
In this case, the course of justice wasn't in fact underway at the point that the defendant acted. So
Yes.
but
so it's preventing the course of justice.
yes.
Yeah, thank you.
And if I ought to have made that clearer in the statement of offence on the indictment, then I apologise. I simply followed the section heading in that regard. I meant to just very briefly add that I obviously heard what your lordship said about timing. I may be wrong, only time will tell, but I suspect we may well be able to conclude this whole appeal within the 2 hours your lordship has indicated.
I suspect so too. I should say that we are most grateful for the submissions from both sides and the authorities in the agreed bundle,
Thank you.
Which we have perused.
Well, in those circumstances, I'll endeavour not to repeat unduly anything that I have said in my written submissions. I do want, after a few remarks, to take your lordships and your ladyship through the authorities that the respondent put forward in the lower court, which I think it's uncontroversial. No one of those cases is on all fours with the facts of this case. I would respectfully submit that probably the case that is of the greatest assistance, both in terms of general principle and to some extent the level of sentence, although I would concede that it is probably a more serious case in the final analysis, is Attorney General's reference 30 of 2010, the case of Bohannon. And it may be, having seen what my learned friend has put in his written submissions, that we are agreed on that, albeit that he obviously seeks to characterize this case as being significantly less serious than Bohannon. As I have endeavored to make plain in the appellant's written submissions, this appeal is advanced on the basis that there is really very little difference in the Crown's assessment of the seriousness of this case and the detailed and thorough assessment which the learned acting justice set out in his written reasons for imposing the sentence that he did. In particular, your lordships and your ladyship will note that at paragraph 23 of his written reasons, he says as follows: unfortunately, the aggravating circumstances of this case more than sufficiently counterbalance its mitigating circumstances. I put the degree of defendant Wheatley's culpability as high and his degree of harm done to others as serious, having regard to the following features of his offence. His lordship then set out in the course of several ensuing paragraphs what he considered to be the principal aggravating features of this offending. And in my respectful submission, he was right to identify each and every one of those features of this case as justifying a significant sentence of imprisonment. The difficulty that the Crown has with the ultimate conclusion is that, with respect, it appears that the sentence ultimately alighted upon was somewhat shorter than the guidelines which the Crown hopes to persuade this court to adopt as of assistance in this case would seem to suggest as appropriate, given those features which the learned acting justice rightly found.
Could you just help me on that? Because it's a matter of some importance. The guidelines are set by the English Sentencing Council
Yes.
After a prolonged consideration. they have no force as such in Bermuda, do they?
Of course not, no, my lord.
No. The question arises as to what extent it is either necessary, advisable, desirable, or possible to take into account in Bermuda guidelines made in England and Wales, whose circumstances of England and Wales are not necessarily the same as the circumstances applicable in Bermuda.
Well, my lord, yes, and I'm sorry if I've started to answer before your lordship has finished.
No, that was a long question, but I finished it.
I noticed that this is a point that my learned friend appears to be heading in the direction of paragraph 7 of his written submission.
Yes.
And he is, of course, right that the guidelines are not binding in Bermuda. And they are, in any event, only guidelines where they do strictly apply. So I would have to accept that they are not tram lines, as is intended in the courts of England and Wales. And he says that while they are useful in highlighting, aggravating, and mitigating factors that may be taken into account, Bermuda has its own statutory code, which the court is obliged to follow, which is set out in sections 54 and 55 of the Criminal Code. See paragraph 17 of the judgment, in which the learned judge set out the relevant provisions. Your lordships can obviously refer to that, and you can look at the actual provisions of the code, should you feel it would assist you. But what, with respect, my learned friend has not done in his written submission, and the reason he hasn't done it in my submission is because he can't, is demonstrate how the guidelines are in any way inconsistent with the sentencing regime that pertains in Bermuda. In my respectful submission, these guidelines, whilst they may not be binding, are inevitably going to be of assistance in a case such as this. We're dealing with an offence which, although it does have slightly different elements, has the same maximum sentence as the offence contrary to section 128 of the Criminal Code, namely bribery under the UK 2010 Act. And one which, on the facts of this case, is directly relevant to the considerations that would guide the court's assessment of the respondent's culpability and also the harm that his offending entailed. In my respectful submission, the offending that the respondent admitted in this case could easily, but for one factor that I'll come on to, have been addressed by means of the precisely corresponding offence under the Bribery Act that has more recently been introduced in Bermuda. But the difficulty is that, unfortunately, the offending period with which the Crown was concerned in this case, namely between the 1st of July 2017 and the 8th of May 2018, in fact straddled the implementation of Bermuda's Bribery Act. And so it would have been necessary to have recourse to precursor offences in the Criminal Code for part of the period, and then the Bribery Act for a later portion of the offending. And further, it's clear, as is asserted on behalf of the respondent, and indeed accepted by the Crown, that not each and every suppression of each ticket that features in this case resulted in a financial or other benefit to the respondent. It would seem that he did at least some of them purely as favours. So in my respectful submission, taking into account those factors, the Crown was entitled to conclude that it was simpler and more convenient to reflect this offending by means of the charge under section 128 of the Criminal Code. But the gravamen of that offending was still very much the intrinsically corrupt action of the respondent, interfering directly with the administration of justice for his own benefit. And albeit that my learned friend seeks to characterize the financial reward flowing to the respondent as relatively modest, and accepting that it's certainly significantly less for example, than in the case of Munger, which is a very large financial benefit in the region of hundreds of thousands. In my respectful submission, still, when one applies the principles that underpin sentencing in cases such as this, it must follow that the rubric that is set out in the UK sentencing guidelines provided for the court of tab 2 of the bundle of authorities is going to be a useful and persuasive one for the purposes of establishing a proper level of sentence in this case. And I say that in part because, of course, if we don't look at guidelines such as those, that there is not a great deal to which the court can sensibly attach its reasoning in terms of figuring out what the appropriate level of sentence is. We've only got one prior authority in this jurisdiction, which is of any comparable circumstance. That's the case of Cosham and Wilson, which appears at tab 1 of the authorities bundle. And
is that a case which was discovered after the hearing?
Well, yes and no, my lord. So it was known about anecdotally in advance of the hearing, but regrettably neither of the parties had located Chief Justice Graham's judgment.
Although it's in the Bermuda law report.
My lord, I think that I have to concede that I, at any rate, did not try hard enough. I imply no criticism of my learned friend. I can see that that judgment should have been before the learned acting justice, and I apologise that it was not. But it wasn't, and the reality in my respectful submission is that even had it been, it's unlikely that it would have had a significant impact upon the sentencing exercise. And I say that because in my respectful submission, with no disrespect intended to learned Chief Justice in that decision, he seems to have been focused almost exclusively on the question of whether or not the non-custodial sentence imposed in that case by the acting magistrate was correct in principle. And in fact, your lordships and your ladyship will note that if you refer to the judgment, it's not until the very final paragraph thereof, namely paragraph 11, that his lordship really enters into any discussion of what the appropriate length of the immediate sentence of imprisonment that he found was required as a matter of principle. The rest of the discussion really is just a exegesis of the magistrate's determination that the matter could, in principle, be met with a significant fine. So,
could you, whilst we're on this, help me with a minor matter? You say that one of the, apart from the point that you just made, and the fact that this is of some antiquity, what was being dealt with was parking tickets.
Yes.
Could we have a look at paragraph 4
Yes,
of the judgment? The Chief Justice there says, the evidence as to a corrupt intent was strong and included email exchanges and SMS text messages, including the following exchange with her boyfriend, Hill. Dutty needs a speeding ticket pulled. Okay, he got cash. Okay, get it from him, yeah. And then on the 24th of June, got more tickets. Can you do those too? Hill, speed, due care, and failing stop. Yeah, I can, but they gotta pay me. Now that doesn't appear to be dealing with parking tickets.
No, your lordship has a keener eye for detail than I. I was relying, as perhaps your lordship has appreciated, in what is said at the concluding sentence of paragraph 2.
Yes.
Where it's indicated that the number of tickets was 79 parking tickets, 9 of which related to a vehicle registered to her sister. So I don't believe that there is anywhere in the judgment indicated what number, if any, traffic tickets.
Yes, but there obviously must have been some.
It does appear that your lordship is right about that, yes.
Right, okay.
I'm sorry to say that, at least as I sit here now, I can't elucidate that point very much. It may, of course, have been that the number of ordinary traffic tickets was considerably smaller than the number of parking tickets.
Yeah.
And perhaps that's why his lordship refers only to the number of parking tickets.
Yes.
I'm sorry, my lord. I see entirely what your lordship is highlighting. I think, although that is a point that, as your lordship is obviously apprehended, I do seek to attach some significance to in my written submissions, namely that we are concerned here with offending that is, in a general sense, more serious than parking tickets. When I say offending, I mean the underlying basis of issuance of the tickets rather than what the respondent himself did. My primary submission as regards Cosham and Wilson really is that it is not a case where there is any detailed consideration given to what the appropriate length of any custodial sentence ought to be in circumstances such as this. The magistrate's court had imposed a fine or fines, and the vast majority of the commentary contained within the judgment is, as I have said, dedicated to shewing conclusively the magistrate's conclusion that that was an appropriate disposal. And it's only in that final paragraph where the learned Chief Justice alights on a sentence of any particular length, which it had ultimately to do, but that's without reference to any guidance, whether it's in the form of case law or guidelines, as to what the appropriate length of sentence would be. And so in my respectful submission, whilst of course the court will have regard to it, it's not likely to be the kind of authority which is going to assist this court greatly, nor would it, in my respectful submission, have assisted the learned acting justice greatly in terms of figuring out how long the sentence should be. And also, of course, and this is an obvious point, but one I think I have to make, the appellant in, the respondent in that case was not a sworn police officer as the respondent in this case is, and that can only, in my respectful submission, be an aggravating feature of this case. So, in my respectful submission, when one considers the detail of the guidelines that the Crown relies upon, and as reflected in tab 2 of the bundle of authorities, they are, in my respectful submission, a good fit for the features of this case. And the learned acting justice appears, in my respectful submission, correctly, to have concluded that they did reflect relevant features of this case, and that the Crown was correct in seeking to attribute high culpability and either category 2 or category 1 harm in this case. Now, I say that because as the learned acting justice expressly found at the first subparagraph of paragraph 23 of his reasons, it is obvious on the facts of this case that this respondent had a leading role in the course of the offending at stake here. He was the linchpin, in my respectful submission. Without his particular access to the machinery of justice, it would have been impossible for anyone to have conspired in the way that he has accepted doing. And in my respectful submission, as the learned acting justice noted, his use of brokers whose own cases are as yet unresolved, but which the respondent by his plea accepted, necessarily puts him at the heart of this offending. So unless I'm mistaken, I don't think that my learned friend really contends that if the guidelines are of assistance, the respondent can properly be characterized as anything other than having exhibited high culpability in this offending. The rather more difficult determination for this court or with respect to the lower court to make is perhaps what the difference is between category 1 and category 2 in terms of harm. And I would highlight in respect of each the third bullet point. In my respectful submission, clearly we're not in category 3. There was here undermining of the proper function of local and national government, business or public services, which was at the very least significant and may indeed properly be characterized as serious. Over the page then to page 3 of 5 within the guideline, it follows from those propositions in my respectful submission that the court would, assuming that it attaches significance to this guideline, be looking at either a starting point of 5 years based on culpability of A and harm in the category 2 remit, or a elevated starting point of 7 years if it considered that the undermining of the proper function of local or national government, business or public services was in fact serious. And the learned acting justice analysed that to some extent in his written sentencing decision. In particular, I would refer the court to paragraph 18 thereof. Having reviewed the sections of the criminal code which my learned friend relies upon as a basis seemingly not to follow the guidelines that the Crown relies upon, which with respect I don't see follows.
So did you say paragraph 8?
18.
My lord, no, I'm sorry, I said paragraph 18.
Thank you.
Just pausing there, thank you for referring to paragraph 18, which I hadn't completely picked up what I'm about to say until you did so. At paragraph 18, he says in the second sentence, it's patently obvious, though, that those offences that reveal mid to high levels of culpability and significant to serious harm will invariably result in an immediate custodial sentence. That's a general expression of view. It's not wholly clear whether what he was saying, as it were, to himself was that this is a significant to serious harm case. Because what in fact happens when you get to page 13 of the judgment, it's the very last paragraph of paragraph 23.
Yes.
His lordship uses a heading, serious undermining of the proper functioning of the BPS and the justice system. And then he says, as stated earlier, such offences as that which was committed by defendant Wheatley has a significant impact on the integrity of the BPS and the court. So he uses both. He uses in the paragraph 18 serious dash significant, and then in paragraph 23 under the heading serious, he says the defendant had a significant impact. When if you're going by the letter of the guideline, it makes a difference whether it's serious or significant.
Yes. I follow your lordship's point. Of course, the difficulty, and I'm not suggesting that the guideline makes this absolutely clear, is what is the dividing line between what is merely significant and what is actually serious.
I mean, the trouble is that whenever a police officer fiddles the court system, other than de minimis, it could be classified as serious.
Yeah.
And the phrases serious and significant have a certain, well, A, as you've just observed, they don't have any definition, and B, they have a certain elasticity.
Yeah.
On one view, serious is dealing with the sort of circumstances in the cases where the English courts thought that 6 years was a starting point before a plea of guilty, where things happened over a long period of time, involved police computers, large sums of money being received, as opposed to receiving $7,500 for various traffic offences. The problem as it seems to me, forgive me going on a bit, is that the judge appears to have been following or assisted by the guidelines. But when it comes to working out how he got to 2.5 years, he doesn't link that to the table in the guidelines. The ratio in that respect is non-existent, unkind, is opaque. But if we look at the table, if we could,
Yes.
page 33 of the guidelines, the way in which these things work is that you have a starting point.
Yes.
But you then have a category range.
Yes.
And if one takes, for instance, the starting point, under category 1 harm and capital A culpability, it would seem a bit much that for an offence of this kind, one would have a starting point of 7 years. That's a year above what the Court of Appeal in England shows in Mahoney. And if one takes into account that once you've got your starting point, you then have to go through the process of deciding what the category, where you go from the starting point, and whether that depends on various aggravating factors and factors that reduce the seriousness. And at page 4, the factors that reduce the seriousness include no previous convictions, remorse, and good character,
Yes.
all of which were applicable to this defendant.
Well,
Weren't they?
Yes.
well, I mean, I know that that's Mr. Horseman.
The Horseman says yes, I thought he would, but is that
Yeah.
not right?
And I respectfully submit that in the particular context of this case, we need to be a little bit careful about that. I'm not saying that those factors weren't present to some extent, but I think that they need to be viewed through the lens of what the English courts have said in the other cases about the significance of those factors. But I don't want to, I'm happy to take your lordships to what I submitted the relevant portions of the other judgments now, but I think if I do so, I'm probably interrupting where your lordship was headed with the question.
Yeah. Let me just tell you where we're getting to. If you look at the category range for category 1, culpability A, and the category range for category 2, culpability A,
Yes.
you've got 5 to 8 years custody or 3 to 6 years custody.
Yes.
If you take the midpoint between the bottom of those, the midpoint between 3 and 5 is 4. If you took 4 and allowed a discount for plea, you would in fact get 2 years, 8 months. But you would get very close to the sentence that the learned judge imposed. So it might be thought, or it might be that he thought, that he would take the lowest of the category range between category 1 and category 2, but high culpability, producing approximately 4, producing after plea a sentence of 2.5.
Yes, well, I see Mr. Horseman nodding vigorously as perhaps.
Don't worry about Mr. Horseman nodding, worry about me.
Yes, my lord, I'm sorry. I follow entirely the course that your lordship has set out. But with respect, I don't see anywhere in the reasoning of the learned acting justice that one can really anchor a conclusion that was his thought process.
You're quite right, because we can't tell from what he said, or rather from what he didn't say, what his thought process was. But since we're considering whether or not the sentence was manifestly inadequate, if that was an available thought process, it could be said that although on the low side, it wasn't manifestly inadequate.
Well, my lord, what I would respectfully submit is that even if one considers that within the meaning of the guidelines, we are in this case in the territory of significant undermining of the proper function of national government instead of serious undermining. In my respectful submission, when one considers the factors, the aggravating factors of this case as identified by the learned acting justice, and as I'll perhaps come on to in a moment, it's not realistic in my respectful submission, even if it puts this case in culpability A, category 2, to say that it falls at the bottom end of the range that's applicable to such an offence. In my respectful submission, this is the kind of case which must reasonably fall either towards the upper end of the range for that offence, or lower within the range for culpability A, category 1. And I think perhaps now that it may be that it's time for me to dive into some of the other authorities.
Yes.
And I did mention, I'm not going to go through them in the order in which they appear in the bundle, but just some very brief prefacing remarks. Respectfully, it appears to me, and I submit, maybe clear to the court, that the majority of these cases are concerned with misconduct, and actually I think almost without exception, the offence at issue in these cases is the English common law offence of misconduct in a public office, which we don't have a precise analogue for in this jurisdiction. But obviously it's similar to section 128. I would suggest it's a character of offending that can cover a fairly broad range of circumstances. And obviously it necessarily requires the individual concerned or an individual concerned in the offending to have a public office. But so practically speaking, in my submission, did the offending issue here. So I would suggest that it will be seen from an analysis of most of these cases, and Bonhanan is an exception, that they are not concerned with misconduct that had the practical impact of actually interfering with the proper operation of the authorities in the way that the offending did in this case. That's not true of Bonhanan, and there is, in my respectful submission, an instructive passage in the judgment in that case at paragraph 64, which is on page 636 of the judgment, which may assist. The court there actually concludes a review of some of the other cases that are included in the bundle of authorities with the following remarks. And I'm now reading 2 sentences into paragraph 64. It seems the list of 4 points commences. First, punishment and deterrence are always important elements in these cases. Not only must police officers be deterred from misconduct, but also the public must see that condign punishment will be visited on police officers who betray the trust reposed in them and do not live up to the high standards of the police service. Secondly, an incentive, usually money, but it need not be, inevitably increases the seriousness of the offence. Thirdly, misconduct which encourages or permits criminals to behave in the belief that they will be kept informed of areas to avoid in connection with their criminal activities, or those who might be informing on the police, also increases its gravity. This is reflected in the observation of the learned judge who commented that Ahmed had boasted that it was like having his own police station at the end of a phone. Fourthly, any misconduct that impacts on police operations moves the offence into a different category. So that, in my respectful submission, is an important distinctor when one is comparing and contrasting the decision in Bonhanan with the others that appear in the bundle. And in my respectful submission, it's important in this context, as I have endeavored to set out in my written submissions, and perhaps don't need to repeat at length now, that the respondent occupied a particularly responsible and privileged position in this case. He wasn't simply a police officer, he was a police officer attached to the court liaison unit. And so in my respectful submission, that further aggravates the seriousness of this offending, because he had, through that position, very close access to the operation of the courts. He was entrusted with certain important functions, both in terms of the court's security and in terms of the management specifically of traffic matters before the court, that are not reposed in each and every police officer, and which necessarily, in my respectful submission, elevates the degree of trust that was reposed in him, and therefore the seriousness of its breach. And that is, in my respectful submission, an important feature of the case. I'm not suggesting for a moment that the learned acting justice wouldn't have been aware of that, because of course he sits as the senior magistrate on a daily basis and would have, prior to the detection of this offending, have been very familiar with the nature of the respondent's duties, probably seeing him in court, as many of us did, on a daily basis. But in my respectful submission, it's important that the court understands the nature of the respondent's role. And with respect, since obviously none of the members of the court sitting today are residents, it may well be that you wouldn't be familiar with a police officer occupying quite that kind of position within the court structure, as is the case here. So in my respectful submission, he's in an elevated position of trust, even when compared with a fellow officer. And that's an important feature of this case.
Yes.
So I want to just take your lordship through the other cases that are included within the bundle. I'll try, if I can, to tie what is said therein to some remarks that my learned friend has made in his written submissions. I just want to make sure that there's nothing else that I want to draw your attention to, in particular in the case of Von Hannon.
Mr. Richards, could I ask a question? I'm not sure whether you're going to be referring to it, but do we need to be concerned about benchmarking by reference to co-defendants or potential co-defendants in the sense of the brokers?
Milady, I don't think so. We don't, unfortunately, the proceedings as regards the two individuals that were indicted with the respondent are stuck at the moment because of the recent developments. We would have moved along a little swifter than we have, were it not for the pandemic. They need to be gotten back on track as soon as that can now be accomplished. I'm not, forgive me, I'm not certain that I've understood your ladyship's question.
Right, sorry, I wasn't making myself very clear. I mean, sometimes when one's considering sentence, one looks at what other defendants have received, and one does some sort of check by reference to the culpability of the respective defendants. Here, I'm just inquiring whether you are taking the point in any way to support your submissions on an increase, that the sentence that has been imposed, as it were, doesn't give much room for imposing appropriate sentences on brokers who may, it be argued, are of lesser culpability? Or is that something we simply don't have to take into account or shouldn't take into account?
Well, I'm grateful to your ladyship for raising the point. I must confess that it's not one that has exercised me greatly, so I think it would...
Okay, well, that's fine. If we don't need to take it into account, we just can put all that out of our mind. But I could see situations where there might be an argument, well, this doesn't leave much headroom, as it were, for sentences that might be imposed on other lesser guilty or arguably lesser guilty perpetrators in
Yeah.
this operation.
Well, I follow your ladyship's train of reasoning, but I think it would be disingenuous for me to suggest now, since the point has really only occurred to me as a result of your ladyship's question, to say
Yeah,
that
okay, that's fine. That's all I need to know.
headroom. And I also, thinking about it, I mean, yes, there are brokers involved, but each of them was involved in a relatively small fraction of the tickets that
Yeah.
this respondent. So, I mean, I think, yes, there is a clear basis to differentiate between them should the other individual be convicted. But
But there isn't a headroom argument you're putting, or a bench, you know, if you benchmark this person so many years, it's difficult to find enough headroom to give an appropriate sentence to others. That's not part of your submission.
It's not been, no. I mean, obviously, if it's something that concerns the court, then the court can look at it. I don't
think it need concern us greatly. I mean, the brokers didn't have the responsibilities of the police officer.
No.
They weren't responsible for the operation of the system. They didn't get the rewards of the police officer. They got whatever commission they got.
Yeah.
And they appear not to be pleading guilty, so that's their problem.
Yeah.
Yeah, okay, that's fine. As long as I know there isn't an argument, a headroom argument, as I call it, that's fine.
Thank you. So I just want to go through, and it probably is easiest if I simply go through them.
Yes.
The other cases that are included within the bundle of authorities. The first of those is Kite, Keat, I'm not quite sure what that is. That's at tab 3 in the core, in the authorities bundle. Again, it was an offence of misconduct in a public office. In my respectful submission, it's important to note that in common with some of the other cases within the bundle, that was a case that involved misuse of the police national computer. And the gravamen of the offending really attached to the expectation that the public rightly have in the confidentiality of their data. That there was not demonstrated in that case any consequence, any real consequence of harm on the proper function of any public service. So in my respectful submission, that is not a case where the course of justice was in any way impacted. And I would make...
Mr. Richards, you would accept that it involved a breach of trust for profit?
Yes, absolutely, it does, yes. And I mean, that is, with respect, a common feature, I think, of all of the cases that are contained within the bundle of authorities. I would simply refer back to the paragraph that I've drawn the court's attention to in Von Hannon, which makes the point that where the misconduct has a real impact on police functions or court functions, that necessarily elevates the seriousness of the offending. And that is something which is absent from this case. And in my respectful submission, another factor to bear in mind when analysing this case, and indeed some of the others contained within the bundle, is that they were authorities on appeal against sentence by the defendant. And so in concluding, as the court did in that case, that the sentence that was imposed could not properly be described as manifestly excessive, the court is not necessarily saying that the sentence could not have been longer. And that is a point which we will come on to in the course of one of the other judgments within the bundle, where a different constitution of the Court of Appeal seems, to me at any rate, to be saying that authorities such as this are, for that reason, of limited assistance. The appeal in the case of Nazir, in my respectful submission, although factually involving conduct very similar to that at issue here, necessarily is distinguished from the circumstances of this case because it consisted of the suppression of a single ticket, which, sorry, this is tab 4 of the bundle, which was admitted by the appellant defendant as soon as he was challenged by a senior police officer. And I'll come back to this, but that's a point in my respectful submission that the court has to bear in mind. Yes, this respondent is entitled to full discount for his guilty pleas, but his acceptance of responsibility for this offending certainly did not come at the very earliest stage that is exhibited in the case of Nazir. And bearing in mind that that case is concerned with but a single ticket and the particular circumstances of that case, it's perhaps unsurprising.
I don't think we're going to be assisted much by a sentence for a single fixed penalty ticket.
Well, your lordship puts the point that I make more concisely than I do. I shall.
Well, it's almost a minuscule offence.
Yes, as is reflected by the outcome.
Yeah.
So, in respect of the case of Kasim, which is found behind divider 5, again, I would make the point that this appears to be a case where there was no impact on the course of justice or the proper function of government. And in particular, I would refer your lordships to a passage in paragraph 13 of which is on page 16. Your lordships and your ladyship will see a section that begins at the left margin with the learned judge went on to say that the appellant's greed had the possibility of putting people at risk. And then this is the sentence that I referred to in particular. He accepted that there was no evidence that anybody had in fact been harmed, but it was also clear that the knowledge that the appellant had deceived the people concerned and had imparted confidential information that had a distressing effect upon them. So in my respectful submission, this case is then in that regard similar to that of Keat, in that in the particular circumstances, the conduct, though constituting, as Justice of Appeal Smelly has pointed out, a grave breach of trust, did not exhibit the important feature of this case, where there was, at least in my respectful submission, a significant interference with the proper operation of the machinery of justice. Moving then to the decision in O'Leary.
Isn't, just pausing before we get there, isn't taking material off police computers in order to sell it to a Saudi Arabian diplomat a form of interference with the function of government, which is to keep these things confidential and safe?
Well, I can see that that's a way in which it could be described, but in my respectful submission, it's clear from the court's judgment that it did have significance to the fact that there was a limit to the harm that had in fact been caused by the particular offending. I mean, in this case, there is no doubt that a number of individuals who ought properly to have appeared before the courts did not do so as a result of the respondent's actions. And given the particular function that he was or ought to have been discharging and the trust reposed in him in that regard, that in my respectful submission can only sensibly be characterized as at least a significant interference with the proper operation of the course of justice, if not indeed a serious one. Now, the point that there are really 2 points that I want to try to elucidate from the case of O'Leary, and these do tie into something that the Lord President was asking me earlier, and something to which I know my learned friend attaches significance, namely the respondent's good character. If your lordships and your ladyship would kindly look at page 319 of the judgment in O'Leary, and in particular at paragraph 8, your lordships will see that, again, the point here is made that no police operations were in fact prejudiced, that nobody escaped arrest, and the course of public justice was not in fact perverted as a result of the information given was true, but his conduct, and the judge created a risk of these very damaging consequences, and if any of the things that had come about would have been a severely aggravating factor which would have affected the sentence. So again, this seems to be a case where happily the full potential consequences of the appellant's actions did not eventuate. But the particular point that I want to tease out from this judgment, which is actually one sentence ahead of where I just reached, is the fact he was of good character did not amount to a significant mitigation because police officers were inevitably of good character. The fact that he would face a number of problems as a former police officer when serving his custodian did not merit a reduction in that sentence. That, in our judgment, remains the case, despite the fact that we have been told that indeed he has encountered serious problems while serving his sentence. So there, in my respectful submission, the Court of Appeal endorses the sentencing judge's view, which appears to be consistent with the view taken by the learned acting justice in this case, that whilst the court cannot, consistent with the criminal code, entirely disregard the good character of an individual such as the respondent, it necessarily carries very little weight in the context of offending of this sort, because of course he, by his actions, exploited in which he found himself, which is necessarily bound up with the fact that he lacked, until these proceedings, any previous convictions.
I'm slightly puzzled by this. There are lots of categories of individual who are almost invariably of good character. But to say, well, that doesn't count for much because people like you usually are, seems counterintuitive. I mean, let's assume we have a doctor and he does some wicked crime, and it's relied upon as a relevant consideration that he's of good character. Say, but most doctors are of good character, so that doesn't count for much. Seems rather odd.
Well, my lord, respectfully, I disagree. And unless your lordship's hypothetical entails offending that the doctor was only able to commit because of his status as a doctor, I mean, the situation here is it not, that the respondent was only in a position to commit these offences because he was a trusted police officer who had, presumably through his reliable or apparently reliable service, secured for himself this position within the court liaison unit. So in my respectful submission, whilst I of course accept that it cannot be completely ignored, it cannot assist him greatly to say I'm of previous good character.
No. But isn't it
intrinsically with the nature of his service?
Wasn't it relevant in the sense that for him, the fall from grace, as in the case of the good doctor, would be even more impactful than it would have been for somebody of previous not good character, someone having previous convictions?
Well,
here the result was that he lost his job, his career.
Well, my lord, respectfully, it would seem that certainly the approach that taken by the English courts as reflected in the judgments that we put forward before the court today, that if that is a factor, it is one of limited relevance. I mean, the court here expressly minimizes the significance of the fact that a custodial sentence is harder for a police officer. And I mean, it is clear in my respectful submission from the general principles that underpin sentencing in cases such as this, that the fact of the defendant's special status, responsibility, and trust is an aggravating feature of this offending. And I mean, the learned acting justice deals with it in the course of his sentencing remarks. And I would refer to paragraphs 19 to 22 of his written reasons for sentence. In particular, at paragraph 21, I do not find the defendant Wheatley's fall from grace or the likelihood of him having a difficult time at Westgate to be proper mitigating features of this case. To be fair, I do not think Mr. Horseman is suggesting they were. Police officers who engage in criminal activities, especially in circumstances where it was breach of trust, should expect to have their reputations tarnished and to be in prison with those whom they once may have imprisoned. I mean, it's an odd feature of my submissions in this case that I'm saying that, albeit that the ultimate conclusion that the learned acting justice reached was one which the Crown contends was manifestly inadequate, in fact, much of the course of his reasoning appears to the Crown to be correct. And albeit that it seems to have been the learned acting justice's understanding that Mr. Horseman was not relying upon those criteria, it appears to me, and perhaps to the court from what is said in his written submissions, that he is before this court attaching or inviting the court to attach significance to those factors. And in my respectful submission, what the learned acting justice said about it below is very much consonant with what the English Court of Appeal said in this decision, and indeed says elsewhere in the cases that are before the court. I did say earlier that I was going to touch upon the issue of what assistance is to be gained from cases that are appeals by the defendant, where the court has simply said that the sentence is not manifestly excessive. And in fact, that is a point that is touched upon in O'Leary, paragraph 11, where their lordships said, we are not much assisted by these citations of authority. And in fact, your lordships can see by reference to the immediately preceding paragraph that the authorities they're referring to were Pete, or Kite, and Cassim, both of which we've referred to already. So to continue the quote, where this court has upheld a sentence, Mr. Wood did observe the facts of Cassim were in some ways more serious than the facts of this case, but in other respects they were, in our judgment, less serious. So, albeit perhaps it's not spelled out explicitly, what I would respectfully submit the court appears to be saying here is that just because another constitution of the court has found a particular sentence not to be manifestly excessive does not mean ipso facto that the sentence that was imposed in that case was the right sentence. It may indeed have been shorter than it could have been. And of course, the application in O'Leary, following from a sentence of 3.5 years imprisonment, was refused. Then we come to...
Can you help me on that? The sentence was, the appeal against sentence was refused, and the judge, the court, seems to be in a view that the starting point of 4 years after a trial was appropriate. If you compare the facts of that case with the facts of this case, in this case, serving police officer pleads guilty to 6 counts of misconduct, which consist of passing sensitive and confidential information to a former police officer to give to criminals.
Mm-hmm.
It might be thought that that's of a higher degree of magnitude than fiddling around with some traffic tickets.
Well, obviously, if the court ultimately concludes that that is so, then it's likely to conclude that my submissions are not well-founded. But in my respectful submission, this case, as is made clear from what is said at paragraph 8, it is not a case of direct interference with the machinery of justice. And certainly the position that the Crown has sought to take both in the court below and seeks to take now is that the particular gravamen of this offending is that the defendant, in the position in which he was situated, directly interfered with the proper operation of the machinery of justice. And it may well be that the court is ultimately not greatly assisted by the particular determination of any of the cases that are included within the bundle of authorities, because none of them is on all fours with the circumstances that pertain in this case. What I'm hoping to try to achieve by reviewing the authorities is to extract what seem to be the and in my respectful submission, an exercise that involves saying that this case is less serious than that decision and more serious than the other decision is a very difficult one to conduct, because each of these cases exhibits its own particular facts and circumstances, which means that there will be, and I accept that there are respects in which on the face of it, this offending is more serious, but equally in others, it's less serious. And that's very much what the court in fact says at paragraph 11. So the key point that I'm seeking to extract from this judgment is not really one of comparison as between this case and that case, but the simple fact that in the circumstances of cases such as this, good character cannot be a significant mitigating feature. The case of Turner, which is actually an Attorney General's reference, appears then to Divider 7. Again, this is a case involving access to the police computer. And in fact, it's a different case from this case for a particular reason in my respectful submission, namely that, as is made clear at paragraph 31 of the judgment, the information that was supplied improperly to others was provided rather than sold. Here, even if not every ticket that the respondent suppressed resulted in a financial benefit to him, clearly that was a substantial portion of his corrupt motivation. There are also factors that are set out in paragraphs 33 and 34, particular to this case, which I think the court will see resulted in the imposition of a shorter sentence of imprisonment than perhaps the Court of Appeal thought ought to have been imposed originally, because unusually the offender had been in prison for a short period on remand and then released and then had to go back in again as a result of its determination on the Attorney General's reference. And so, although it did ultimately agree with the Attorney General that the sentence should not have been suspended, I think it's fair to say that the sentence that it ultimately imposed was adjusted to some extent in order to reflect those unfortunate circumstances. So, in my respectful submission, whilst of course a learned friend will make what use of it he can, that is a very different case from the that is presented to this court. And the same can be said, and I've already dealt with Don Hannon, but the same can be said in my respectful submission in respect of the last judgment in the bundle, the case of Munger. That is a very different case.
Before you go on, Mr. Richards, at paragraph 33, your lordships nonetheless resolved that a sentence of 18 months imprisonment would have been appropriate.
Well, there's a lot of adjustments going on. Forgive me, my lord, I've dropped something that I need to retrieve. There's a lot of adjustments going on here in my respectful submission to reflect the particular circumstances of the case. I mean, I think ultimately the conclusion is that the sentence which the learned judge imposed in that case was not inappropriate, but that it should not have been suspended. But then, as a result of the particular circumstances, a somewhat shorter sentence was ultimately imposed.
But in any event, the appropriate sentence would have been 18 months immediate imprisonment.
So your lordship is referring to the sentence, however, allowing for all the circumstances, not least of which is the element of deterrence, a sentence of 18 months imprisonment
Yes.
as the judge thought would have been appropriate. Yes. So they there appear to be saying that 18 months imprisonment would have been appropriate on the facts of that case.
Yes.
I've endeavored to elucidate that is a very different case from the case that confronts the court on this appeal. Bearing in mind that, again, we're concerned here with accessing police national computers. It does not appear to have been any financial benefit to the respondent in that case, as a result of his actions. He simply provided the information and did not sell it. That's a very different case, in my respectful submission, factually, from an individual such as the respondent, interfering directly with the machinery of justice by suppressing certainly tens of traffic tickets and thereby arresting the proper implementation of the machinery of justice in respect of that offending for, in the main, financial reward. So I would respectfully resist any contention that because the court seemed to be of the opinion that, although it didn't ultimately impose 18 months appropriate in that case, means that it would be appropriate in this case. Again, as I've said, I don't think that any of these cases is really on all fours with the case before the court now. But on any view, in my respectful submission, the case that's before the court must be more serious than the case of Turner.
Okay.
So then we come to the last case in the bundle of authorities. Again, this is a case of unauthorized access to the police computer. The real gravamen of the offending in this case appears to have been the significant financial reward that the appellant obtained, running into the hundreds of thousands of dollars. And of course,
It's Munger, is it?
Hungary, yes. No.
I'm sorry, my lord, I didn't hear you.
Manga,
Manga,
what question, what case we were looking at?
So your lordships and the ladyship will see from paragraph 2 that it was the business concerned. I may simply read. The essence of this offending was that the appellant used his position over that period of years to make unauthorized access to the police computer system and thereby to obtain details of road traffic accidents, which he then sold to solicitors firms who used the information to contact those who had been involved in the accidents for the purpose of pursuing claims for compensation. For this purpose, he set up his own company. It was a lucrative business producing illicit income over the period in the sum of approximately $363,000. So, I mean, clearly in that respect, more serious than the offense in this case. But again, I would say that in another respect, it's less so because there is nothing apparent on the facts summarized in the judgment in Munger to suggest that the machinery of justice was being interfered with. Obviously, solicitors were being provided with confidential information to which they were not properly entitled, and then were going on to use it in order to chase a few ambulances. But in my respectful submission, the appellant in that case was not acting in the way in which the respondent in this case has accepted acting. And so, albeit that one can understand why the English Court of Appeal took the view that the sentence imposed was necessarily going to be of significant length based upon the financial advantage, it does not follow, in my respectful submission, that because the financial advantage in this case was somewhat less, it must necessarily be viewed as significantly less serious.
When you say somewhat less, I mean, this was an offense which took place over 7 years when he accessed personal data 21,802 times and trousered £363,000. That's rather a large quantity of offending.
It is, yes. And
They say that the figures are different, is true, but the difference is enormous.
Yes, that's true, but in my respectful submission, the more fundamental difference is not in the remuneration, it's in the nature of the conduct.
There was a serious invasion of privacy of the individual people and the exploiting of his position of trust. I mean, this is very serious indeed. The fact that it's not interfering with prosecution of people for illegal parking or for road traffic cases is neither here nor there, is it? I mean, it's still extremely serious, as my lord said.
Well, I agree with your ladyship, it is. But then so is this case, in my respectful submission, for different reasons. The gravamen of this offending does not lie in the obtaining of very significant financial advantage, as it did in the case of Mundo. It lies instead in the direct interference with the machinery of justice perpetrated by the respondent as a result of his particular position and the trust reposed in him. So they are, I freely accept, very different cases, but to the extent that it's suggested that because the ultimate sentence of 4 years imprisonment in that case was deemed by the English Court of Appeal to be appropriate, a sentence of 2.5 years imprisonment in this case is not manifestly inadequate, presupposes that there are many points of commonality between the cases. And in my respectful submission, it's a different case involving, yes, the breach of trust element, but not exhibiting the interference with the course of justice that is the serious feature of this case. So in my respectful submission, and I think I've really made this point, the cases that the learned friend puts forward are not without content that may assist the court, but none of them really matches the features of this case. And I would respectfully submit that the court ought to be significantly assisted, even though not strictly binding, by the guidelines on which the Crown relied in the court below, and which it again relies now. In my respectful submission on the application of those guidelines, the court ought to have taken a starting point of not less than 5 years imprisonment, and indeed could properly have taken a longer starting point based upon its assessment of where the case lay between categories 1 and category 2. It's against that background that in my respectful submission, the court's conclusion that the sentence of only 2.5 years imprisonment, notwithstanding the substantial areas of agreement that the learned acting justice seems to have had with the Crown's submissions on sentence, was and may properly be described as manifestly inadequate. I just want to make a few further points in reference to my learned friend's written submissions on this appeal. I've spoken already about the point he makes in paragraph 2 about good character and the value of that, which, as I respectfully submit, is necessarily limited in a case such as this. It's also asserted, and I know that my Lord President referred me to this mitigating feature as listed in the guidelines, to the issue of remorse. My learned friend says, as the judgment notes, Mr. Wheatley apologized to his police colleagues who were present in court to support him. The whole affair came to a complete shock to all who knew Mr. Wheatley. Now, of course, that's true, but in my respectful submission, that is a fact that the revelations as to what he had been about for at least several months was a complete shock, is in a sense an aggravating feature of this offense, because the respondent's actions were fundamentally deceitful. He was concealing, understandably because of the nature of the enterprise, his fundamentally corrupt and dishonest conduct from his colleagues. He was, in a sense, a wolf in sheep's clothing. So, in my respectful submission, it cannot avail him to say that his colleagues were shocked. The reason they were shocked is because he was lying to them. He was deceiving them. He was acting in a fundamentally corrupt and dishonest way, whilst presenting to them as a colleague worthy of trust and respect. It's also noted in his favor that on the date of sentencing, the respondent submitted his resignation to the Commissioner of Police, and his career as a police officer of some 14 years came to an end, as a result of which he lost his livelihood. Now, of course, those are factors that the court can take into account, but in my respectful submission, a resignation that had come earlier in the course of these proceedings, perhaps at the point of charge, would have been more explicit in its indications of genuine remorse. Instead of which, respectfully, it appears that the respondent continued to claim his monthly salary as a suspended officer of the police force until he really had no choice the day that he faced up to the reality of the situation and admitted these offences. His resignation at that stage of these proceedings, in my respectful submission, cannot reasonably be characterised as an illustration of profound or sincere remorse. He left it until the 11th hour, in my respectful submission. And so, again, I would respectfully submit that that is a factor that cannot advance him considerably on this appeal.
Does he lose his pension as a result of this conviction?
Yes.
Yes, he was suspended, as I understand it, he was suspended immediately from the point of apprehension.
Yes.
I don't want to suggest that was not clear from the point of my learned friend's involvement in the matter, that there were discussions with a view to seeking to resolve this matter otherwise than by way of trial. So I don't have a considerable issue with the awarding of the standard credit for a guilty plea at the earliest reasonable opportunity, because that was the nature of the discussions that my learned friend and I were having from an early stage within the proceedings. But prior to the respondent being charged, there was not, in my respectful submission, any clear indication on his part that he was going to accept responsibility for his corrupt behavior. That certainly wasn't apparent to me from anything that he said on apprehension or in interview. And in my respectful submission, yes, it may well be that he did satisfy the learned acting justice that he had some level of remorse, and yes, that's a factor which the court can take into consideration. But I mean, to suggest that the fact that he resigned on the date of conviction is evidence of the sincerity of that remorse, in my respectful submission, attaches too much weight to it. It may very well have been an eloquent expression of that remorse had it been done at an earlier stage, but it wasn't. It was done when he really had no choice in the matter, in my respectful.
What difference does it make, Mr. Richards, if it's agreed that he should get the full benefit of an early guilty plea?
Yes, my lord. So I'm not disputing that he gets the third credit for a guilty plea, but that's a separate consideration on the guidelines, in my respectful submission, from an assessment of remorse. So if your lordship looks at tab 2, page 4 of 5, as my Lord President invited me to consider, there is listed in step 2 the consideration of aggravating and mitigating factors, the latter of which includes lack of previous convictions, remorse, good character and or exemplary conduct. And that's before we come on to step 4, which is where we consider any reduction for a guilty plea. So
Presumably you accept that no previous convictions is relevant, although most police officers have no previous convictions.
well, I don't wish to appear difficult, my lord, but it's not irrelevant. And at least one of my colleagues will berate me for the use of the double negative. But I choose that phrase deliberately because I respectfully submit that on the analysis of the authorities that I've endeavored to take the court to, it's not a factor that can, in the particular circumstances of a case, attract very significant weight.
Yes.
I don't say that the court should totally disregard it, but it's not the kind of case where, in my respectful submission, the offending is entirely divorced from the good character of the defendant. And, you know, in that sort of situation where the defendant has lived an entirely independent, a life of credit-worthy behavior entirely independent of his offending, one can understand why the court will attach considerable significance to good character, but that's not the case. And so in my respectful submission, for the reasons I've endeavored to elucidate, the sentence that was imposed by the learned acting justice was manifestly inadequate, and I respectfully invite this court to impose instead a sentence of between 3.5 to 5 years imprisonment, which is the sentence for which the Crown contended in the court below, and which it maintains would have been appropriate in this case, and should therefore now be imposed. Unless I can assist your lordships any further, I think really those are my submissions.
Thank you.
Thank you.
Thank you. Yes, is it convenient, Mr. Horseman, for you to start now?
Yes, I'm fine to start now, my lord. So, my lord, will come as no surprise that the appellant and myself submit that this sentence was not inadequate at all. Indeed, as described in one of the last cases that we looked at, a 2.5-year sentence was described as severe. And my learned friend is right, my lord. None of these cases that we've looked at are on all fours with Mr. Wheatley's case. In fact, my submission is they're far more serious. This is not to detract from Mr. Wheatley's case that it was a serious case. It was a breach of trust, but it was traffic tickets. It was, I think the figure that we arrived at was $7,000. The loss to the government of Bermuda was calculated to be $20,000. Many of these tickets were simply pulled as favors. In my respectful submission, my lord, when you're looking at this offense, which carries a 10-year maximum, when you look at the facts of this case, and you take into account, I mean, my learned friend, good character, it does count, my lord. The fact that he had no previous convictions, it does count. Typically, of course, in these cases, the perpetrators do not have these mitigating factors, but that's part and parcel of why the offense is treated as more serious, because it's an abuse of trust, an abuse of the position. But that's factored in when one looks at the factors that we take into account under Section 55. And I think it's important to remember when my friend is saying, well, you don't take into account or shouldn't take into account good character, or the fact that he has no previous convictions. Section 55 is a statute by Parliament that says the court must take it into account. Of course, it's for the court to give such weight as it deems appropriate, and in certain cases, it will count more. But this was a police officer and an individual before that who had no previous convictions, a 14-year unblemished career. He obviously got off the path, and he, as indicated, my learned friend, we had ongoing discussions, and part of the discussions were centered around, I was trying to, about what type of level of sentence the Crown would be asking for. And it took some time for us to get there. I don't want to get into those discussions, but you've heard the Crown was asking for 3.5. I went into court asking for 18 months. And the sentence for the magistrate came, or sorry, not the magistrate, the learned judge came up with was 2.5 years. It was a serious prison sentence. And unfortunately, we didn't have the case of Wilson. We were aware of it. I tried to search for it, but unfortunately, it must not be properly programmed into the database from which we searched, because neither myself nor my learned friend could find it. I'm grateful for Mr. Richards going back and being fair to Mr. Wheatley and finding the case and presenting it before this court. That case, my lords, is on all fours. There's not much to distinguish that case from the present. And as my Lord President has pointed out, it appears that it just wasn't a case of traffic tickets. It was a case of road traffic offenses. There were more tickets pulled, 79. And the distinction that my friend seeks to draw, whether it was a sworn police officer or in this case, they both wear a blue uniform. If you walk into the Hamilton police station, you'll be hard pressed to tell the difference. The fact of the matter was they're both abuse of trust cases in similar positions. And one wonders, had that case been presented to Justice Wolf, a sentence might have been less. But indeed, there's a case that Mr. Wheatley could say, I have a real sense of grievance looking at Miss Wilson, who had she actually went to trial and was aborted. The trial was aborted, when no doubt her counsel convinced her that going to trial was futile. And even then, the former Chief Justice, Mr. Ground, imposed a sentence of 12 months, but said he would have imposed a sentence of 18 months, but as an act of mercy, given the time that had passed since the imposition of the fine, only imposed a sentence of 12 months. But, my lords, this is the first time I've been faced with the sentencing guidelines of the UK in my 25 years of practicing in Bermuda. And I was still trying to figure them out, and I'm grateful to my Lord President's interpretation, because perhaps I'd just like to briefly make my observations on them. If you could turn to tab 2. And first, at paragraph 12 of the Crown submissions, my learned friend seems to accept the Crown respects, contends that the harm in this case must amount to at least significant undermining of the proper function of local or national government business services, category 2, and quite possibly serious undermining. I mean, my learned friend seems to be accepting that this could fall into the category 2. As my reading of the learned judge's judgment, he seems to, although he prefaces the paragraph with serious, he's clearly referring to significant. But if you're looking at the table, and perhaps I could start first at the bottom of page 2, and I think my Lord President clarified the matter. Having determined the category at step 1, the court should use the corresponding starting point to reach a sentence within the category range below. The starting point applies to all offenders, irrespective of plea or previous convictions. So if my friends accepted this category 2, starting point is said to be 5 years, but a category range of 3 to 6 years of custody, that's before you take into account a plea, previous convictions, remorse and the like, then, I mean, there's a good argument that this sentence, even under the sentencing guidelines, could have fallen to could have fallen under 2.5 years. The learned, in looking at the judgment, and I'm just looking at the last page, right above paragraph 24, the learned judge goes on to say the only saving grace that it does not appear any police intelligence investigations or operations were compromised or affected by defendant Wheatley's conduct. I just say that just looking at the categories, one could argue that you're sort of looking at a category 3, limited detrimental impact on the government, business, or public services. But I don't need to put it that low. Mr. Wheatley accepts, my lords, that this was a serious offense. But in the context of traffic tickets, $7,500, or a loss to the Bermuda government of $20,000 has to be put in context against, he's lost his, yes, he resigned on the last day, but the fact is he lost his career, he's lost his lifelong pension. You know, it's a serious penalty has been placed on him. And yes, the court doesn't take into account that time is harder if you're a police officer going to prison. So I don't place any reliance on that. But in no way can this sentence be said to be manifestly inadequate.
Mr. Horseman, could I ask this question?
Yeah.
Does the defendant lose all his pension or just some part of it?
Well,
I mean, presumably he must keep something that reflects his own contribution if it's done in that way.
Yes, that's correct, my lady. As I understand it, once you're a police officer, after you've been in the service for 25 years, then you basically get a portion of the salary for the rest of your life. At this point, you know, having served 14 years, you're getting close to that. It's a big loss. And certainly police officers, you know, if you're getting that close, you want to make your 25 years. But yes, his contributions into the government superannuation fund would still be, you know, they can't be taken away from him.
No.
But the lifelong pension that police officers, long-serving police officers obtain, you know, that's gone.
And
what about the government's contributions over the 14 years?
That's a good question, my lord. I don't have the answer to that.
I ask it, yes.
What was he actually getting paid by way of salary at the time of the offences?
My lady, I don't profess to know that, but knowing the salary ranges, I would be saying probably about 85, between 85 and 90,000. I'm purely guessing, but I mean, I know sort of the starting ranges for beginning officers and more senior officers. He was a police constable, so he's on the lower end. So I'm saying roughly about 85,000, and that's in the context of the high cost of living in Bermuda.
Yeah, of course.
Yeah.
Mr. Horseman.
Yes, my lord.
Is your submission that notwithstanding the English Court of Appeals approach in O'Leary, that police officers in particular ought not to have previous good character regarded as a mitigating factor? That in Bermuda, because of requirements of section 55(2) of the Criminal Code, the court must nonetheless take it into account in the case of police officers?
Yes, my lord. The statute says, and Parliament has mandated, that these are the mitigating factors that the court shall take into account.
It does use the word shall, doesn't it?
Yeah. Perhaps
I don't think it's suggested that the court shall. I don't think the Crown is suggesting that the court should not take good character into account. What is being submitted is that it doesn't count for very much,
Yes,
which is different.
yes, my lord. I appreciate that. We more rely on.
I suppose the question then becomes, how does the court take it into account? In ordinary circumstances, it is regarded as a significant factor, reducing sentence. In the case of a police officer, how does the court approach it? What are your views on that?
Well, certainly what I would say is, as I preface my submission, he was a good character before he became a police officer. So he's had that part of his life. He's been an officer of 14 years. The length of service, obviously the last year or two would not count towards his good character, if I may phrase it that way. But no, it's not going to count or carry as much weight, my lords, as if it was, the average person on the street. But on the same respect, you've had somebody that's never been in trouble, for a length all their life up until this point. It should count for something. The main mitigating factor is the plea of guilty. So when you're looking at the range of the sentences, but the court shouldn't ignore that Mr. Wheatley, has been a good character, has served this country for years, and unfortunately, took a wrong turn and ruined his career and his life. And no doubt he'll be able to come back from it.
Both counsels seem to be agreed, as the judge found, that the English guidelines should be of general applicability. That is what he says at paragraph 14 of the judgment. In relation to mitigating circumstances, though, the guidelines do not purport to be categoric or exclusive. And they do mention factors such as whether the defendant is the sole or primary carer for dependent relatives.
Right.
They don't specifically mention the impact of the conviction on the defendant as an individual. Are you saying that that must nonetheless be taken into account, or should be taken into account as a mitigating factor?
Well, I say it should be taken into account. And I think we have to be very careful about importing the English guidelines, sentencing guidelines, into Bermuda, where Parliament has made statute to the court. I mean, it starts off with section 54 that a sentence must be proportionate to the gravity of the offense. And Bermuda, particularly concerned with many recidivism and young black men going in and out of jail, has approached sentencing, I think, possibly from a different perspective than the UK, where it says that a sentence of imprisonment should only be implemented if no other penalty can be justified, or you're required to consider whether community service or probation to try and approach it from not just throw them in jail and throw away the key. I mean, I only use that as an example to say we have to be very careful about saying these courts should start applying the English sentencing guidelines when Parliament has mandated how the court should approach a sentence.
So you're inviting us to depart from what the judge found at paragraph 14, are you?
Well, I think if you look at the judgment, and I didn't take great objection to the factors being, I think as the judge found, he found the approaches are very similar. And if I could take you to, if you go to paragraph 17.
That they can, in my view, be applied generally to
Yeah.
equal serious corruption type offenses committed by public officers. such as section 128.
Yes, and if you look, I would say if you go to paragraph 17, the above case authorities and the sentencing counsel extract mirror the sentencing principles set out in section 55 of our criminal code. So I think he's obviously had regard to the sentencing guidelines. He's found that they're very similar to our section 55, and he's gone on to cite section 55. But I think this court should offer guidance that section 55 is what our courts are mandated to apply. And, my apologies, mother. And looking at 18, considering section 55(2) of the criminal code, the cited authorities and the sentencing guidelines that can be likely be meted out for corruption offenses can possibly range from community-based sentences up to lengthy terms of imprisonment. So, on one hand, as I've tried to demonstrate when looking at the sentencing guidelines, in fact, if you start from the framework that this is a, if you start from the framework that this was a significant category 2, there's nothing inconsistent with the 2.5-year sentence and the sentencing guidelines. So my respectful submission, though, as you've seen in my written submissions, is that Bermuda courts should not be constrained by the sentencing guidelines.
I mean, the problem.
Sorry, you go.
No, you go.
Is there any inconsistency between the Bermuda Criminal Code on the one hand and the guidelines on the other that we should pick up? I mean, the judge says that they exactly mirror the sentencing principles, but is that correct, or is there in fact some inconsistency?
Well, where I think the inconsistency is, my lady, is that there's no hard and fast step-by-step process that the Bermuda courts are required to undertake. I'm not clear on, when you look at when we look at these, the Court of Appeal of the UK, the English Court of Appeal cases just looked at, there's no mention of the sentencing guidelines, and it's hard in my submission to see how they pin those sentences within these particular guidelines. So
well, many of the English cases were before the guidelines were promulgated. Well, because the guidelines relate to the Bribery Act 2010.
Sure. Well, that explains it, my lord.
But it could be, I suppose you might say that it could be inferred that the Bermuda legislature preferred to have its judges having greater flexibility in relation to sentences, albeit within the principles laid down in section 55 of the code. They have not nonetheless considered it appropriate to impose the constraints of guidelines, such as they may be and such as there are in England.
Yes, well,
that could be an argument on your part, I suppose.
Well, that was the point I was trying to make when saying, you know, the approach of sentences, you only impose a sentence of imprisonment as a last resort, and the court is mandated they have to consider other avenues first.
That's true, but that doesn't help us, because on any view there was going to be a sentence of imprisonment in this case.
No, I agree with my lord, but I was just merely trying to demonstrate the different approach.
The difference between the two is that the provisions of the criminal code in Bermuda are generic. There are a series of matters that you must take into account.
Yes.
The guidelines are specific. You have to go through a rather elaborate process of categorizing the harm, categorizing the culpability, and then going to a table with a starting point and the range, et cetera, which simply doesn't exist in Bermuda. So to that extent, Bermuda can't be taken to have adopted the guidelines as a sort of straitjacket or as a form of compulsory process, as opposed to illustrative of what may be an appropriate approach. The problem for the court is that in the present case, the judge thought that the guidelines were generally applicable, and the exercise that he performed was in effect, by reference to the guidelines, to assess whether the culpability was at a high level and to address whether the harm was in category, well, whether the harm was in category 1 or category 2, though the expressions that he used in relation to that latter question are confusing, because in one place he refers to it as serious and in the other as substantial. But then when one gets to the exercise of getting to 2.5 years, he does not explain the process by which, by reference to the guidelines which he's previously been referring to, he got to the 2.5 years.
Yes, you're absolutely right, my lord. And perhaps much like myself, the judge has never had to has never had to deal with the guidelines in the past. But I think what the judge was referring to in his judgment was saying, yes, these are the aggravating factors, these are the mitigating factors, and highlighting them, because you can see he goes through the various aggravating factors. But I agree with you. No, he did not go through the exercise of which category 1, 2, A, B culpability.
Yeah.
But in Bermuda, we're not mandated to do that, and the judge should not be constrained in a straitjacket to apply these particular guidelines, particularly given the judges are given wide discretion here, depending on the circumstances.
The trouble is that it looks strange if you embark upon the exercise of going through the first 3 quarters of the exercise, that is to say, working out the culpability and working out the harm. It's rather curious if you then don't follow through to the completion of the exercise.
Well, that's true, my lord. But I think as my lord president opened up the hearing with my learned friend, the question is, was this sentence manifestly inadequate?
Yes.
And whether your lordships would want to give guidelines on whether Bermuda should be adopting these type of principles, I leave that to you. But in my respect for submission,
it's the legislature to decide.
Well, yes, obviously. I mean, my submission is the guidelines have no application in Bermuda. We have section 54, we have section 55. This sentence, obviously the lower courts are subject to the authority of the Court of Appeal. But this court should give due deference to Acting Justice Wolf, who is a senior magistrate on the front line of crime, day in and day out, and has acted in many Supreme Court trials. And the question for this court is, was this sentence manifestly inadequate? In my submission, it can't be said to be. And when my learned friend is starting off saying, well, I'm asking for 3.5, and he makes the argument, well, it's 40% more than the sentence he would have got. My lord, we're tinkering at that particular point still, in my respectful submission. He asked for 3.5. The judge came down with 2.5. That was a serious sentence of imprisonment for someone who's never been in prison before, never committed any crime before. And I think I can end it that this court should not interfere with the sentence. I'm not going to take your lordships through all the cases. I really rely on the Wilson case, where 18 months for an almost identical sentence. Almost identical offense. A much lesser sentence was imposed.
Yes.
And, you know, when you look at the AG's reference, the Bonan case was 6 years. I mean, that was after a trial of 6 weeks. No remorse, no plea of guilty. A police officer, I mean, incredibly, I mean, you've seen the facts, using his position to give information to criminals to evade search warrants, to locate debtors so they could enforce against them or their family members, check up to see whether any of his colleagues were giving evidence against him or become an arc for the police. I mean, that's a whole nother kettle of fish. And when you're looking at the Court of Appeal and increase the sentence to one of 6 years, and you have the other cases, the lawyer who made £363,000 by, and I see it as a far more serious case, invading the privacy of the citizen, and made a vast amount of money over a prolonged period of time, and the sentence was just above what my client received. And the Qasim, which was selling information to the Saudis so they could keep an eye on certain dissidents or citizens that they wanted. He earned £14,000 in my respectful submission, a much more serious offense. Made a similar amount of money in a 2.5-year sentence of imprisonment. The exact same one Mr. Wheatley received was upheld by the English Court of Appeal. So you have my written submissions. I don't want to waste time going through the individual cases, but my respectful submission, my lords and my lady, that this sentence should not be interfered with. It was not manifestly inadequate.
Thank you.
Thank you.
Mr. Richards, do you have any observations in reply or not?
Very briefly, my lord.
Yes.
My learned friend vacillated slightly as between accepting that the guidelines were of assistance and contending that they had no application. In my respectful submission, Justice of Appeal Gloucester has highlighted the essential point here. There is nothing in my respectful submission in the relevant sections of the criminal code that can reasonably be said to be inconsistent with the guidelines. As my Lord President has pointed out, the guidelines are, of course, more specific than the generic guidance contained within the sections of the code, which will be applicable to all cases. But there is nothing in the fundamental approach to sentencing enshrined in those sections of the code, which means that it is not fair or reasonable to have regard to the guidelines as a more specific indication of the approach to sentencing in a case such as this. And so far as the issue of good character is concerned, yes, of course, I accept that that's one that's highlighted as a statutory mitigating feature in the sections of the code. Indeed, it's one that features expressly in the guidelines. So clearly, it's not foreign to the approach that the English courts would take in general terms. It's just that in the particular features of this case, as I have said, it's a factor which necessarily attracts less weight than it might otherwise. And in that regard, I refer explicitly to section 55 because I'm reminded, in fact, of a correction that your lordship's and your ladyship's brother, Justice of Appeal Bell, made when I slipped into a misuse of language in an appeal during the immediately preceding session in March. I used the phrase, which I think has been used during the course of this argument, that the court is required by this section to take certain factors into account. And Justice of Appeal Bell quite rightly corrected me and said that the statutory language is actually the court shall have regard to the factors. That's in subsection 2. And then aggravating features are set out in A and mitigating features in G. So clearly it's apparent from the legislative provisions of this portion of the code that the court is not required to attach any predetermined weight or amount of credit to any particular factors. It's simply required, reasonably and logically, to have regard to them. And there is afforded to the court clearly substantial freedom to attach what significance properly owes to any particular factor in the context of the particular case. And in my respectful submission here, when one looks at the case law and the guidelines, it's clear that that factor cannot be one that attaches or attracts rather significant weight in all of the circumstances. My Lord President also made the point, which with respect I agree with, that the cases that are contained within the bundle do not make any explicit reference to the guidelines upon which the Crown relies. And in fact, the guidelines were actually issued a little bit more recently than the Act under which the offending they cover is criminalized. So your lordships will see that the guideline is effective from the 1st of October 2014. All but one of the cases that are contained within the authorities bundle were decided before that. And indeed, in most cases, significantly before that. Kite is a 1997 case, for example. So the only case that actually was decided after those guidelines came into effect is the case of Munger. So in my respectful submission, there is no great significance to be attached to the fact that the Court of Appeal did not make express reference to the guidelines on which the Crown relies in any of those.
Yes. Thank you.
So, I don't want to waste the court's time with repetition unless there are any questions that the court has for me. I think that those are the submissions I would make.
So far as I'm concerned, I have no questions. I don't know whether either of my colleagues has.
No, thank you.
No, thank you.
Right. Well, I think we'll take a break now and decide how we're going to progress matters. Can you be available in half an hour? I don't warrant that we should be ready in half an hour, but in case we are, I'd like you to be there. Is that inconvenient at all?
No, not at all, my lord.
Okay.
Fine.
Well, we'll, if Quello can help us into our meeting room, we will go to it.
So should we remain connected, my lord?
Well, not necessarily, but you need to be available to be connected in half an hour's time.
Yes. So just to clarify, Mr. Queller, we would use the same login details, Mr. Queller?
Yes, just re-log in into the meeting room and I'll admit you.
Thank you.
So if I were to make sure that I was attempting at least to get back into the meeting at 11:45, I should be available if the court requires me.
Yes.
Thank you.
Yes, please.
Thank you, my lord.
Thank you.
I haven't found the breakout. Oh, here we go.
Hey, Alan,
Hello.
just see. Hi, Mr. Coelho. When did the Court of Appeal finish up, Mr. Coelho? This week?
We finish on the 19th of June.
Oh, okay. Alan,
Sure.
are you guys all back in the office now?
No, I guess maybe come Friday we might be, because we'll be phase 3 by then, won't we? So I suppose we'll have to, at minimum, we'll have to have somebody on the reception desk letting people in. But,
Yeah, we're sort of wrestling with how we're going to deal with it, the opening now.
I suspect, you know, people will probably still try to do a certain amount from home just to minimize the number of people who are in the office at any given time.
Right.
Because we've expended quite a lot of effort making sure that everyone has the capability to work from home. So
yeah, it still makes sense if you can do
productive. Why not carry on?
Mhm.
Hello? Yes, it's me. Yes. Oh, it was only a very brief conversation. I wouldn't worry about that, but thanks. Okay. Bye. Hello? Hello? Yeah. Well, I'm kind of waiting for the Court of Appeal to reassemble, so I might have to go quite quickly. Uh-huh. Right.
Thank you. We'll have Mr. Wheatley, please.
Right. I think we're all present. The court is most grateful for the submissions, both written and oral, that it has received, and for the assembly of the potentially relevant authorities. We are not persuaded that the sentence in this case was manifestly inadequate, and we propose therefore to dismiss the appeal for reasons which will follow in writing hereafter. Thank you very much.
Thank you, my lord. Thank you, my lady. Thank you, Mr. Justice Smelly.
Thank you.